Thank you very much, Christine, and thank you for your welcome and thank you for the invitation. And may I join with your President in acknowledging the traditional owners of the land on which we meet and pay my respects for their elders past, present and emerging. And I hope we are part of a long tradition of gatherings of people who, unfortunately, I have to consider myself an elder these days, who met with younger people to share their knowledge and experience. So that's part of the long tradition of the land on which we meet tonight on this dark and stormy night. As I said before, it's a presage of Halloween, the kind of night we've got tonight. So I thought when I was asked to speak, I was shown some of the previous lectures that had been given, and they were very impressive and often quite theoretical about the nature of advocacy and the nature of the courts. But I thought what I, as a young practitioner, would have liked to have heard from a Supreme Court judge. So I thought of the title, Everything You Wanted to Know About Appearing in the Supreme Court, but were too afraid to ask. And I will speak tonight, hopefully not for the whole time, so that you won't be afraid and you will have the opportunity to ask questions about any topic that you'd like to ask about that are relevant to your appearances in court. And if I can answer them, I will. So let me start with the first slide. It must be accepted that appearing in court, even when you have a very well-prepared case for an honourable client, is always a very stressful experience. When I started at the bar, I realised how stressful it was, and I used to hope that one day I would be like one of the very senior barristers who was very relaxed. Then, of course, I started appearing with them and realised that that tapping foot and that shaky finger showed that it actually never went away. So judges know from their own experience that appearing in court is very stressful. But how much more so it is when your case is ill-prepared or your client turns out to be not as honest as you hoped that he or she would be. So there are some things you can do to try to reduce your stress levels and present your case well. And so I'll proceed to give you a number of tips that I've learned from my long years of experience, first as an article clerk, as we were in those days, then as a judge's associate, then as a barrister, and finally, after 19 years, as a judge. I should say that my mantra at the bar was that there are 3 rules of success at the bar. I shamelessly borrowed them from the real estate agent's mantra of 3 rules of success in real estate, which are location, location, location. There are 3 rules for appearing in court successfully, and they are preparation, preparation, and preparation. As a judge, my mantra has now always become to expect the unexpected. I always prepare for court now to cope with everything that I know is going to happen, is likely to happen, or that might happen. That's because the unexpected always happens. And because it's unexpected, you don't know what it's going to be. And you need all your energy and all your mental acuity to deal with it. If you're still trying to prepare for the known, the expected, or the likely, you won't be able to cope with the unexpected, and it will throw you. For newly admitted legal practitioners and those not familiar with going to court or a particular court, my first piece of advice is go to court. Go to court when you don't have a case on. Sit and observe what happens in the call-over in applications, or on a case flow management day, or on a sentencing hearing, or at the beginning of a criminal trial, or take a snapshot from a civil trial. There is nothing that will teach you about what you should do in court and what happens in court better than going to court. It may be interesting, it may not be, but you will always learn something. It's extraordinary to think that the first time you might go to a court is when you have to perform something important in that court. So, visit courthouses, get to know those courts in which you have not yet appeared. Make the court as familiar as your own workplace. Somewhere you feel familiar with the environment, the roles of all the people, and the expectations that judges and other courtroom personnel and registry staff will have of you. I always start a jury trial by saying to the jury, who are very unfamiliar with the environment, very formal environment they've just found themselves in, this is our workplace. The lawyers here and the court staff and me, we feel at home here because this is our workplace. We know it is a very unfamiliar and formal environment for those members of the public who come in and do their jury service. But as a lawyer, make sure that it's not a formal and unfamiliar environment for you. Just make sure you come to court, take those opportunities you get and come to court and just sit and watch and see what goes on and learn from it. My next piece of advice is to be polite to everyone in court. It is a workplace and not a battlefield. Be polite in particular to the courtroom staff, the bailiff, and the judge's associate. They may act as the judge's eyes and ears, and they are always the judge's stalwart supporters. I see that there's at least one past associate in the room, and if you ask the associates, you'll find out how much they incidentally hear, and how much, if a practitioner is rude to the associate, they may well tell their judge, and their judge will, of course, think less of that practitioner. If you're rude to court staff, you run the real risk of the judge will hear about it, and while the judge may or may not say something to you about it, your reputation will be tarnished by your behaviour. This includes being polite to your opponents. A judge is in court to solve a problem, or indeed many problems. Nothing grates on a judge like legal practitioners who are rude to each other or point score in an unpleasant way. That doesn't help the judge solve the problems before the judge. It is distracting, and again, it will make the judge think less of you and not of your opponent. The need for courtesy is particularly true if your opponent is a self-represented litigant. I know from my own experience, both as a barrister and as a judge, that such a litigant can be a terribly difficult person to appear against. Such a litigant also presents problems to the judge. Such a litigant will usually be much more stressed about the situation and about appearing in court than you are. They will be intensely emotionally involved in their case. It's your duty as a professional to endeavour to create, whenever you can, a calm atmosphere and to organise the material so the judge understands what the real problem is and therefore how to solve it. Because self-represented litigants are often extremely disorganised because of their unfamiliarity with what goes on in court and the proper procedures and their often extreme state of heightened emotion, you have the opportunity to organise the material and to present it to the court in a calm and unemotional way. I have observed, and trust me, I remember the names of legal practitioners who I have seen adopt this approach. Such an approach will surely enhance your reputation with the court. Now that brings me to what really is the central point for a legal practitioner in court. You may have a fine academic record. You may have landed yourself a good job. You may work with congenial colleagues and have interesting clients, but the judge knows nothing of that. All the judge knows is how you behave and how well prepared you are in court. It's by your performance in court that you will earn your most important reputation. That is your reputation for honesty, reliability, and knowledge. That reputation takes a lot of work and is hard won, but unfortunately, it's also easily lost. However, if you have built a good reputation in court for honest, reliable, and skilled work, you'll be much more likely to be forgiven for an occasional slip-up when something you hadn't expected to be a problem becomes a problem and you make a mistake. Let me move on to appearing in applications where probably is the jurisdiction where most of you would be likely to appear in an advocacy or an instructing role. As you will all no doubt know, in the Supreme Court in Brisbane, 2 judges usually sit in applications. On Mondays, 1 judge will do applications under the Dangerous Prisoners Sexual Offenders Act, but on each other day, generally there are 2 judges sitting, although that may change if a judge is urgently needed for some other matter or the list is closed down, so it's limited to matters only before 1 judge. The applications jurisdiction is always overlisted, so that more cases are set down than can be heard by the judge or judges who are sitting on that day. This is because matters may be adjourned, they may settle, or the parties may reach agreement. So in order to maximise the time available to the profession to set matters down urgently, the court always allows an overlisting of those days. Consequently, at the beginning of the day, there's a call-over in which the senior judge will want to assess how long your matter is likely to take. When an application is listed in the registry, you'll be asked for your time estimate. The general rule is that the matter should be expected to last no longer than 2 hours, although if you and your opponent make an approach to the associate of the senior judge in applications in the week in which you wish to list your matter, you may be allowed to list a matter that will take longer than 2 hours if there's time available in that list. So, at the call-over, you'll be asked by the senior judge in applications how long your application is expected to take. This is a very important question for the judge, and the judge needs you to be as accurate as you possibly can. It is surprising, even shocking to me, how seldom it is that the time estimate given at the call-over is the same as the time estimate that was given when the matter was listed. Sometimes there might not even be one matter where the time estimate is the same. It's because the matter will now take less time because the parties have discussed the questions in issue and reached agreement about certain matters or reduced the matters in dispute, there's no problem. But there is a problem if a party who set a matter down for 20 minutes now says it will take an hour and a half. As I've said, the applications are already overlisted, so that extra hour you seek may make the list unworkable. When you give your time estimate, remember you're giving a time estimate for your submissions, your opponent's submissions, any submissions in reply, questions by the judge, reading time by the judge, and then time for the judge to give an extempore judgment. Before the call-over, a judge will commonly ask if there are any consents or adjournments. By adjournments, the judge is not asking for a contested adjournment where one party wants an adjournment and the other party does not, and the matter will have to be argued. By consents, the judge does not mean are there matters on which the parties have agreed, but the court will have to read the material and the judge exercise the discretion. That may be a short matter of, say, 5 to 10 minutes, but it is not truly a consent order. If you, and even the other side, have decided you do not want an application heard on the day it's set down, you cannot just not turn up. If it has not been successfully adjourned on the papers, it's your professional obligation to the court to appear and explain the situation. If you appear with what is truly a consent adjournment to another date, make sure you have checked the availability of the time you seek on that date, so the judge can in fact adjourn it to that date. So that's the call over. Now, what about the hearing of the application? As soon as you come into court for an application to be heard, the bailiff will seek an appearance slip from you. Please make sure you filled it out correctly, with the correct spelling of the names of the legal practitioners who are to appear. I told you it was going to be everything you needed to know but were afraid to ask. Perhaps you don't realise you have to spell the names of the legal practitioners correctly, but it's very embarrassing for the judge to read the appearance slip and address someone by name and then discover that's not their name, or at least that's not how it's spelt. And unfortunately, it happens. It's not a usual practice to say good morning or good afternoon to the judge. You may think it polite to do so, but there is a good ethical reason why, unless the judge greets you in that way, it's not appropriate for you to greet the judge in that way. The ethical reason may be fairly simply expressed. Many judges know many legal practitioners personally. After all, judges were in practice themselves prior to their appointment. They may have been in chambers with a barrister, or they may have been in a firm with a solicitor who appears in court. They may even be personal friends. But in court, any such relationship is irrelevant. And unless there is a conflict which means the judge is or should be disqualified from hearing the matter, the judge will be hearing the application and treating each party dispassionately and without fear or favour. If a legal practitioner who knows a judge greets the judge in a more familiar way, the other party, whether a legal practitioner or even more so when the other party is unrepresented, may feel that they have been excluded or are not part of the club. Any such impression would be to undermine the required lack of bias and appearance of lack of bias that a judge must always demonstrate. So, you've got through this hurdle, you've handed up the appearance slip, you haven't said good morning to the judge. After your appearance slip has been handed to the bailiff and then given by the bailiff to the judge will ask you for your material. To get off on the right foot in the beginning, this is what you must do. You must hand up a list of the documents on the file that you wish the judge to read, and you must hand up an outline of submissions. These should be separate documents so that the associate can be handed the list of documents to retrieve from the file, and the judge can be given the outline of submissions in order to read it. I was discussing this with one of my colleagues this afternoon, and he said, yeah, and tell them to give up to the judge working copies of all the documents on which they wish to rely. But, you know, that's a counsel of perfection. I'm just talking about the basic things you need to do. Now, about this outline of submissions. It doesn't matter whether your application is simple or complex. You are required by Amended Practice Direction 6 of 2004 to hand up an outline of submissions. And it's not there just for a matter of form. If you have an outline of submissions, the judge can read it and be satisfied that you've covered all the matters that need to be covered before the judge can make an order. And perhaps even more particularly so when you have no opponent. As likely as not, if you've not prepared an outline of submissions, you will have missed something essential to your application. It never ceases to amaze me when even quite experienced legal practitioners turn up without an outline of submissions because they say to me they didn't think it was necessary. However, when it's done in a relatively straightforward matter, such as an application for leave to withdraw as solicitors on the record, the judge can immediately see that you've covered everything that needs to be covered. Every step that needs to be taken has been taken, and you have thoroughly prepared your matter so the judge can decide it quickly and with confidence in your work. From time to time, I have actually asked younger practitioners to pass on to partners for whom they work that I've specifically asked them to tell the partner that the employee has done an excellent job and thoroughly prepared the matter before me. And when it happens, it's a great joy for the judge. But it is amazing, unfortunately, that really quite experienced practitioners will turn up without an outline of submissions, hoping to wing it and hoping, I don't know, the judge will wing it too. A much more difficult situation arises for you when you're a junior person who's sent to court to appear in a matter about which you know nothing. I know it happens. It happened to me, happened to my son when he was a law graduate. I presume we're not the only two lawyers in Brisbane to whom it's ever happened. So let me say to all the senior people present, do not do it. Do not do it to a junior person. There is nothing more demoralising and humiliating to a very junior practitioner than to turn up in court knowing nothing about a case, to be asked one or two questions by a judge who wants to know the answer and who will then immediately realise that they have someone before them who is no use to them at all. When that happens, I feel quite angry towards that young legal practitioner's principals who put the young lawyer in that situation, and it is not helpful to your client. I've had to stand matters down to require someone who does know something about the file to come to court to answer the questions so the matter can be progressed. A matter is not mentioned in court for the sake of it. It's always because the court wants to progress the matter. If you're handing up submissions in a more complex matter and you're referring to legislation, case rules or cases, it is always an advantage to hand up a copy of the relevant material to the judge. When you're preparing your argument in such a matter, do ensure that you know and place before the court any authorities that do not support the contentions for which you argue. A judge will not thank you for putting a one-sided argument or just ignores any law or any case that's contrary to your argument. You won't be surprised to know that judges want and need to make correct decisions. If a case is against you, perhaps you can legitimately distinguish it. Or it means that your case is not tenable. When you do your research and are thoroughly prepared, these are the matters that you need to think about. It is certainly the duty of any advocate not to mislead the court so that the court makes a decision that is wrong in law or ignores some relevant facts, and in the applications jurisdiction in particular, the judge will be relying upon you to bring all these matters to the judge's attention. The next matter you should always consider before you come to court is the orders that you seek. After all, you come to the applications jurisdiction either to seek or to resist orders, and even if you're resisting an application, often there will be orders that you seek in order to defeat that application, or you may have a cross-application. If so, then not only do you need to think out precisely what orders you seek, but you should draw up a draft to hand to the judge so that the judge is more easily able to make those orders if necessary. You do need to think carefully about when to hand up a draft order. If the matter is relatively uncontroversial, the judge will be greatly assisted by having a draft order first, so when you hand up your material. If, however, the matter is controversial and hard fought, the judge may be taken aback if you hand up a draft order right at the beginning before the arguments have even been made. You'll have to use your judgment on this one as when to hand up a draft order. All I say to you is just make sure that you do have one so that you can hand it to the judge when the judge wants to make an order or to consider what orders can or should be made. Finally, can I remind you that ex parte communications with the judge's chambers are almost invariably inappropriate. If you feel you need to communicate with the judge through the judge's associate, the correct approach is to first obtain the consent of your opponent and always copy any such communication to your opponent. It's better if any communication with the court, with the judge, comes from both or all the parties involved. Now, that's my brief overview about what you need to know, the basics that you need to know about appearing in the applications jurisdiction. May I add some brief remarks about case flow management days? I did these for about 10 years. I heard on the grapevine that they were called the naughty list. I can't imagine why. If your matter has been listed in the case flow management list, it's because you've not filed a request for trial date within 180 days of the pleadings being closed. The expectation is that cases should be ready to be heard by that time, and the parties should have filed their request for trial date. If you've not, your case will be listed and you're expected, in consultation with your opponent, to draw up a draft set of directions which the judge can make that will ensure that your matter is prepared so that you can file a request for a trial date by a certain specified date. There is a comprehensive practice direction governing case flow management. Make sure you read it before you come to court. It's Practice Direction 17 of 2012, and you should read it carefully and make sure you comply with its requirements. So depressed was I by even lawyers not being able to read and understand the practice direction that I prepared a plain English guide. I pretended it was for self-represented litigants, but really it was so that lawyers would not come to court not knowing what to do. You'll find it on the court's website under practitioners' case flow. There's just been a new case flow judge appointed, so she will be taking over, and so it is important that you read that case flow practice direction, and the case flow management plain English guide will help you. It's a checklist, really, of what you have to do. When I was a practitioner, I made up for myself checklists of what I had to do if I was appearing in a certain kind of matter, what I would have to go through to make sure it was properly prepared, that I'd covered everything. So as a judge, I have tried to devise practice directions that will be that checklist for practitioners. So it's very depressing if the practitioner doesn't bother to read it before they come to court. If you have a civil trial in the court, you should ensure that you've complied with practice direction number 9 of 2010 in setting trial dates and ensuring the matter is in fact properly prepared for trial. Our court has been so concerned about the lack of proper trial preparation that a new position has been created at our court of resolution registrar. An experienced litigation lawyer has been appointed to the position. So if you have a matter in which you've signed the request for trial date now, you can expect that your matter will be much more closely managed by the resolution registrar and, if necessary, by a judge to ensure that all of the matters that need to be attended to have been prepared so the matter can be heard fairly and expeditiously, and that there are no last-minute need for amendments or adjournments, and that as a result, clients do not wear unnecessary costs of what is, we all know already, a very costly business. So here are some of the matters that you need to be thinking about when your matter is coming on for trial. The pleadings. I know it's where we start, But just earlier this week, I've been teaching at the Judicial Orientation Program, which is the week's program for new judges appointed to Supreme and District and Federal courts around the country. And these are the kind of things that we've been talking about. These are what practitioners need to do when they have a matter that is set down for trial. So the pleadings. Are they actually the pleadings that you wish to rely upon at the trial and at the end of the trial? Do they canvass properly and correctly the matters you want the judge to decide? You may think it's obvious, but I can't tell you how many times the need for amendment becomes clear during a trial, or even after a trial, or even worse, on appeal. So that's one of the things you need to be thinking about. Are these pleadings the final form of the pleadings that you want to rely upon? Then, having sorted out the pleadings, you should then be looking at what are the facts that are not in dispute. Can the parties agree that there are a list of facts that are not in dispute and don't need to be litigated? Are there any issues that are no longer in dispute? There always are. And it's depressing how much time can be wasted in a trial litigating facts or issues which in final submissions then the parties say are not actually any longer in dispute. Try to work that out beforehand to save your clients money and the court's precious time. So look at the facts that are not in dispute, the issues that are no longer in dispute, and then what are the facts and issues that remain in dispute? In other words, what does the judge have to decide? You should really be able to set that out on a piece of paper in consultation with both parties or all of the parties. What are the facts and issues that remain in dispute that the judge has to decide? Then, once you've worked that out, do you have evidence that deals with each of those issues? So are you able to prove through evidence all the things that you need to prove for the facts and issues that remain in dispute? Are there remaining problems with disclosure? I know we have court rules and I know parties certify that it's all happened, and then during the trial someone will get out their diary and say, yes, I know this meeting was on this day because I wrote in my diary. And all the lawyers go, diary? What diary? None of us knew about the diary. So make sure that all the issues covering disclosure have been sorted out and you've thought about, are there any remaining problems with your disclosure or any disquiet you have about the disclosure of the other parties? Have the experts produced joint reports? Have you given consideration as to how the experts will be giving their evidence? Would it be useful, for example, to have 2 or 3 experts giving their evidence at the same time? Think about how the experts will be giving evidence. Have you agreed a bundle of documents with the other parties? And if not, why not? Because you'll be asked to do it if you haven't. You know, just imagine how wonderful the resolution registrar will feel about you and how good your reputation will be if you come to one of these directions hearing with all of this covered and knowing the answer to it and having prepared all the things that need to be done to have a trial run properly. Have you discussed with your opponent and tried to resolve any objection to evidence or to the documents? And importantly, do you have a realistic trial plan with all of your witnesses available during the trial? And are you sure that there are no ways of finalising any of the issues or indeed the whole of the matter without the need for a judge's decision? These are some of the matters you should be considering and that you will definitely now be asked about whenever you have a matter for trial. Finally, can I say to you that the judge's role is to solve problems as fairly and justly as possible. Your role in court is to assist the judge in that role by fairly and fearlessly representing your client in order to assist the judge in fulfilling that important role in the civic life of this state. Thank you, and I'm happy to answer any questions. Yes?
What's the judge's attitude?
You told everyone they had to wait for a microphone.
Oh, sorry.
See, rule-bound judges.
What's a judge's attitude when other parties put in spurious material in their affidavits, and how does that impact on the judge's attitude when they're dealing with the matter in the courtroom?
Well, judges are human beings, and if you get spurious, irrelevant or clearly incorrect material in affidavits, of course it has a detrimental effect on your case. I'm glad you assume that it's only your opponents who will do it. So, it's very important, the material you put before the court, and of course it will have an impact on the credibility of the witness if there's material in it that's irrelevant or self-serving or clearly incorrect or provably incorrect. Yes?
Judge, I've always had opponents consent to me writing to a judge's associate about a matter that I feel needs to be addressed. But I was just wondering, what if they don't consent?
You can't do it.
But you are ethically bound to raise something with the judge, for example?
List it.
Thank you.
It's, as I say, it's almost inevitably inappropriate. I can't say it's always inappropriate because I can't, there might be a case where you'd have to do it. For example, if, all your opponents were hit by on one bus and they all died. But
no, I was thinking about something that you have to raise.
Says, if you have to raise something and your opponent does not consent to your raising it in writing with the judge's chambers, then you just ask it to be listed and then you raise it in open court. I had a fairly unpleasant, a bitter experience at the bar of my opponent going to see the judge, asking for a solicitor going on the other side, seeing the judge and saying the matter had to be listed urgently because counsel were only available on a certain date. Now, counsel can be singular. The judge's chambers assumed, as you would expect, that it meant counsel plural, but it didn't because I hadn't been asked and it wasn't. And so, of course, the first thing I did when it was listed was raise the objection. It did not do my opponent's case a pile of good. But if you're saying, there's something that needs to be changed on the record and you're ethically obliged to raise it, then just list it. Any other questions? Yes, the lady with the glasses. No?
Just a quick one.
Yeah, sure.
In relation to self-represented litigants.
Yeah.
Obviously, any practitioner appreciates that a self-represented litigant is just doing the best they can with the knowledge that they have, but often in protecting your clients' interests or advocating for them, you need to pick out particular issues, if things have not been put into the court already.
Sure.
What are your tips on sort of doing that, politely or in such a way that you can balance protecting your own client's interest but also not coming across as mean or...
Yeah.
They already hate you enough.
Taking points just for the sake of it. Look, as I say, when I see practitioners being polite and courteous and a little bit helpful to an unrepresented litigant. That legal practitioner just, my estimation of them rises, and it probably helps the legal practitioner's case, because it's always going to be very difficult for the judge if the person hasn't done this or that or covered this or that. My own experience as a practitioner is I appeared once in the AAT in a matter where a person was unrepresented, and they had some good points, but they were totally disorganised. So what I thought was my obligation, my professional obligation, was to organise the case and say, these are the things that the member of the AAT had to decide, set them out and set out what the arguments were on each side. You're not just a mouthpiece for your client. The judge will rely on you to be a professional in the room. And if you note that the person hasn't raised something, it may be just that they've overlooked it, or it may be a big hole in their case. So it requires a bit of discretion on your part. But remember that you are the professional in the room along with the judge, and the judge will rely upon you to exercise that professional judgment as well as courtesy. Yeah.
Thank you. Judge, I was just wanting to get your opinion on advocates calling on judges before they appear for them for the first time. There's a few of us here from the Commonwealth DPP, and we appear on our own sentences a lot in all jurisdictions. So I was just wondering what your view is on that.
It's a most interesting one. I was an associate to a High Court judge who'd originally come from Brisbane, and he said it's a very Queensland thing. If people finish the bar practice course, they're encouraged to ask judges if they can call on them. These days they're coming in groups. I think that's a very good thing, to have that informal conversation with the judge. But if it's because you're just about to appear before the judge, it can be a bit tricky. I don't mean you're being tricky, but it can be just a little difficult, because then suddenly if the judge is seeing the legal representative from one side and not the other. So I followed the practice of calling on, when I went to magistrates' courts, but then just something happened once and I thought, I'm just not comfortable with this. I'm not going to do this anymore. What I do, because I didn't have a criminal practice at the bar, generally, unless the lawyers have behaved atrociously, which has happened once or twice, I invite the barristers to my chambers when the jury's out in a trial, just because then we can have an informal cup of coffee and, get to know them slightly. But I think if you're appearing before someone, calling upon them that day, it can be dangerous. It can just lead to a compromising situation or the appearance of a compromising situation. So what happened to me once was a district court judge said something to me about my case. And of course I had to tell my opponent. It was terrible. I just thought, I'm not going to do this anymore. I think in a situation like that, if you're in the country and you think it'd be polite to call upon a judge or magistrate you haven't appeared before, take your opponent.
Yes, thank you.
So that there's no potential for the appearance of anything compromising. Yes?
Could you flesh out for us a bit more you talked about, you put the cases that favour your side's story to the judge, and then you mentioned, now I understand that in an ex parte application you have to also tell the judge about the cases that are against your side, but were you saying that in a normal contested that you also, where do you draw the line between
yes, you
doing
do.
the other
It's actually
advocates?
ethical obligation. It's because you're making submissions on the law, and if you say the law says this, and that's half of what it says, or a quarter, you're not complying with your ethical obligation. Now, as I said, if a case is against, say, I had I'll give you an example. So I was doing call over in applications, and a matter came on. They said it was hotly contested and take this long and blah, blah, blah. And then I had to do another milling call over later in the day because there's so many matters. And those two barristers came in, and one said he'd be submitting something, and I said, but there's High Court authority contrary to that. And he said, well, nevertheless, that'll be my submission. And I thought, well, luckily I knew there was High Court authority contrary to that, but you can't make a submission that's contrary to High Court authority unless you've got some way of distinguishing the case, or the facts are different, you know, in law or in fact, some way of distinguishing it. You can't just say, oh, well, that's my proposition, and I'm going to put that to you as my proposition of law and invite you to decide the case wrongly.
No, I think what I was more getting at was, where do you draw the line between, because if I argue every single case against my client's story and every four, you're going to get my case and then the other side's case, he's going to do the same. You're going to get the same thing twice, almost.
I don't know.
Isn't that his job to
Not
argue that?
really. No, you're putting forward the law. If you say the law is as set out by the House of Lords, where they said blah, 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 and you know that case was overruled, or you know there's High Court authority to the contrary, you're not you're not making your submissions correctly. I'm not saying you have to refer to 50 cases on this side and 50 cases on that side, but if you put a proposition of law and there is a case or a statute that's against it, it's your ethical obligation to say that. And as I said, in your preparation, you'll think, well, you know, that's not actually tenable to say that because it's not correct. Unless you can distinguish it.
Clear, I get that. But,
yeah.
But there's always ways of fitting a case to your facts.
Well, that's good. I'm glad of that. In this particular case, where the person intended to come in and argue something that was completely contrary to High Court authority, there was no way of doing it. But and I remembered that person. I still remember the name of that person. And, you know, the next time he appeared before me, was I prepared to act on the basis of some submission he made? Well, no, of course I wasn't. Very suspicious of it. So I don't mean you have to go overboard, although I did see someone go overboard once in a way that was absolutely brilliant. I was an article clerk. I was briefing Bill Pincus, who was a silk, and because I was a conch, of course, I found some unreported case that said something slightly different from what all the reported and important cases were. So I thought, I've got to tell him this. So I told him about it, and he said, that's very interesting. So he got up before, we had masters in those days, got up before the master and said, it's very interesting. There's one unreported case against this. Let me tell you about it. So the master said, well, it's very interesting. Of course, all the other authority is, you know, and you could see the decision-making. Wow, what a very fine barrister this is. Starts with the matter against him. But of course, it was a great forensic technique because it led to this avalanche of authority that was in his favour. So there are ways of doing it, but we can't all be as skilled as Bill Pincus was as an advocate. But really what I'm pointing to is your obligation not to mislead the judge as to what the law says, and not to do as some people do. I don't know, do they think we can't read? Oh, Your Honour, I refer you to page 382, lines 3 to 5, where it says this. And then you say, yeah, but what about line 6 to 7, where it says the opposite? Oh, you know. I don't know, yeah, maybe they thought we couldn't read, I don't know. But So that's really what I mean. I don't mean you have to prepare the whole argument for one side and then the whole argument for the other side. Yes.
Judge, just a question which touches on where you left off in terms of citing authority. I know there's a practice direction that talks about citing authorised
Yeah.
judgments over unreported judgments.
Yeah.
I suppose my question is, when it comes to citing authority, where do you draw the line in terms of the number of cases you put forward for a particular point? Do you go one per point, or do you just sort of get the latest one, or do you go back to the highest authority?
There's no one answer to that. I remember I was junior to a very experienced not bill pickers, I won't say the name, and we were doing a matter, and he was well known for not liking to read a lot of cases, and I'd prepared it all and had the cases there, and while we were waiting to go on, I handed him one case to read, he read it, handed him a second case to read, he read it, I handed him a third, and he said, "How many cases do you expect me to read?" I thought, 2. If it's a very obvious proposition, you probably only need to refer to the leading authority. If it is a proposition about which there is real debate in the courts and uncertainty as to precisely what the law is on that point, you need to refer to more and to say, well, you know, there's this proposition, that proposition, Your Honour might prefer this interpretation. So it's really horses for courses. You certainly don't need to say something like contract is made up of offer and acceptance and then, you know, the whole list, you know, with the exception of the Carbolic Smoke Company. You know. So, you know, for obvious propositions or more standard propositions, that's too obvious, but you might only need the latest High Court authority. But for others, you'll need more. It just depends on the nature of the proposition you want to put. You can over-egg the pudding, but on the other hand, you can just have not enough. And the judge might say, as I've heard said many times by me and my colleagues, what's your authority for that? No, I don't know. Don't have one. Not so good.
Thank you, Judge. I guess one final question is, say for a concrete example, say the matter related to one of discretion, perhaps 2 or 3 cases one way or the other would be probably an appropriate amount?
Again, it depends. I mean, discretion, House and the King, right, everyone's going to have that. But if it's interlocutory injunction, then you just be looking at what the latest cases say on serious question be tried, balance convenience. You know, but if it's Verweyen, then you might have to look at what's happened to Verweyen since the High Court decided it. There really is no one answer for that. That's really part of your professional judgment. To, as I said, not over-egg the pudding and have 1,000 authorities for things that are obvious, but then not to have sufficient authority for things that are more difficult, where the judge might have to choose between conflicting lines of authority, even within their own court. Judges might have decided differently, so then you'd need more authorities to set before the judge really what choices the judge has.
Thank you.
It's okay, my pleasure.